computer. Hello everyone, my name is Sandeep. I'm a company secretary and I will be moderating today's session. As many of you are aware that R&D is celebrating 30 years this year, and as a part of the milestone, we have planned a series of webinars on a various professional topics. And today's topic is Corporate Laws Amendment Bill 2026, which was passed in the Lok Sabha on 23rd of March. And I believe this has been placed before Rajya Sabha as well. Today there is a Rajya Sabha going on. Not sure Ramakrishna sir will explain that. So today's presenter will be Ramakrishna Gupta sir. And before handing it over to you, sir, I'd like you to explain briefly uh, what is exactly this corporate laws amendment bill. I can see that there are lots of sections which has been amended. How impactful is there for the corporate professionals and the companies, whether it's the leverage has been provided or it's stringent, what exactly it is. Over to you, sir.
Yeah. So good evening to all of you and good evening, madam.
Good evening.
Good evening, good evening. So the proposed bill, Corporate Laws Amendment Act 2026, which has been passed by Lok Sabha and then being deliberated by the Parliament and Rajya Sabha today. So if you recall, I think Companies Act...
Your voice is low. Just please.
Voice is low? Okay.
A bit low.
Bit low. Yeah, I'll increase my pitch. So if you recall, when the Companies Act 2013 was amended, was replaced the erstwhile 1956 Act, the emphasis of this Companies Act 2013 was basically, on the disclosure to the shareholders and giving more accountability to the directors and auditors and KMPs and ensure the investor protection and then corporate governance. So unlike in previous era, now I think governments are taking more and more care and caution in ensuring that the whatever legislations and amendments they're bringing in, whether they're performing as expected or whether they require any changes thereafter. So that is I think seems to be the thinking of the government. So in the lines of this thing, the government has reviewed this Companies Act many times. So far, the Companies Act 2013 was amended in the year 2015 and 2017, 2019 and 2020. And a couple of the constituted committee also, I think Company Law Committee, to review the functioning of the Companies Act. So as a part of that exercise, I think, the companies, the Ministry, MCA wants to propose some more amendments to the Companies Act, broadly to achieving the objective of the present government, the laudable initiatives like ease of doing business, and now this time they added ease of living companies. So meaning the regulatory environment within which the companies are living, functioning, there should be an ease of living, like how we feel that there's ease of life. Likewise, even for the companies also, they should feel ease of living. So in this aspect, broadly, this Corporate Laws Amendment Act 2026 has brought changes broadly on 4 or 5 areas. The area is one area is mostly on the decriminalizing the offences. If you see, the previous acts has decriminalized most of the offences from criminal aspect to monetary penalty. So the implication of fine is being converted into penalty, and then the ROC being authorized to adjudicate such non-compliances and then levy penalty. So the lot of discussion was went in. So for the non-compliance of the Companies Act, and if you see most of these non-compliances are procedural nature, and you can't attribute any mens rea. So even if at all, if you have to attribute mens rea can be attributed to the directors, not to the company. Maybe to certain extent, to bring discipline, even that they are putting the companies also into that bracket and levying penalties prosecution. But over a period of time, as a part of ease of doing business and attract the more and more investment into this country, I think government is trying to see that these are all procedural violations. So let us not make them criminal consequences rather put a monetary penalty. So in that direction, I think they were trying to, they brought major changes in various under various sections. From fine to penalty, and also they're trying to reduce the discretion of the register of companies while adjudicating penalty. So if you see a couple of sections, there is a range. The penal consequence, it says that penalty or fine of up to 1 lakh or up to 2 lakhs or 5 lakhs. Now they're removing that discretion, because whenever there is discussion, again we come across and we experience that discussion as a cost. Discussion comes with a cost. So I think they're trying to avoid that. Second, also there is a lack of provision in the Companies Act in case ROC adjudicated and levied a penalty, and there is no provision for recovery. And now this Companies Act is trying to ensure that whatever penalties they are imposing, they're introducing the provisions for recovery of the penalty. By recovery, more stringent norms they're introducing there by recovering those amounts, penalty amounts from the personal assets of the directors and KMPs and KMPs. So those provisions were also introduced. And apart from that, I think the corporate mergers, I think they're trying to bring more ease in corporate mergers, especially when the companies are located beyond the multiple, more than one jurisdiction. So that more detail we'll discuss.
How are we discussing, sir? Are we discussing in a consecutive section wise?
I'll just finish in another 2 to 5 minutes max about my introductory remarks, and then we will go by section. So ideally, section by section, we'll try and cover whatever today we can cover them. And maybe I think we may have to have one more session to complete the entire proposal. Let us do in those lines. And third amendment they are bringing is that to encourage more and more companies coming and registering under IF, International Financial Services Center, that GIFT City. So they're bringing the provisions to enable them to issue shares in permitted foreign currency. We'll discuss them in detail there. And then some small CSR amendments are also they're bringing. And the auditor, I think, now the role of an auditor is becoming more and more vigilant, more and more sensitive, because NFRA has been giving more teeth to investigate into the affairs of the companies, especially on the financial aspects of it, and then undertake the disciplinary aspects of the auditors of the company. So these are the broadly changes they are trying to bring it. So one side, when they say relaxation and disclosure, and giving more and more, allowing companies to disclose it and function it. As long as you disclose, it's fine for us. So the government doesn't want to regulate, but they're making more and more accountable to the directors and auditors and KMPs. So broadly, these are the emphasis this Corporate Amendment Act 2026 is covering. Yeah, Sandeep, and last statement. So somebody was the other day was raising an observation saying that why it is Corporate Law Amendment Act. Generally, if you see, in the acts when they amend the act, like Companies Amendment Act, or IBC, Insolvency Bankruptcy Amendment Act, or LLP Amendment Act, but why corporate law? There is no such act called corporate laws. So how come this law was presented as a Corporate Laws Amendment Act? Here, I would like to clarify things. See, if you see, the government doesn't want to bring for each and every amendments which they propose in a multiple legislation in different amendments, because that is a different proposal per se in the Parliament in Lok Sabha. Mostly the major amendments which has impact of the finance budget, they bring in the amendments in the finance budget itself, and through finance bill, they can amend any legislation for that matter. Well, today at present we don't have finance budget, so I think they are bringing in the form of a piece of legislation for which they can adopt any mode of amending the legislation. So since now the proposal is to amend the LLP Act and the Companies Act, so both being a corporate kind of legislation, so they named it as a Corporate Law Amendment Act. So you do not have an act called by a corporate laws, but this is an amendment. This itself is an act. But the implication of this act is such that this act will amend the existing Act of Companies Act and LLP. So that is the clarification there. Now Sandeep, today we'll take up the amendments in the Companies Act. So we will go by section by section. Highlight wherever the major implication is there. I will elaborate that implication of the proposed amendment. And wherever no penal provisions are there, I think we will not spend much time there.
Okay. I'll share the screen, sir. Then.
Yeah, please stand.
Sir, I want to make one comment with respect to decriminalization.
Mm.
So, if you say that the fines are converting into penalty, and ROC generally, I don't feel there is an adjudication process. There is no when the penalty is there, he does not have an option to reduce the penalty, right? And ultimately, the company has to go for an appeal. So, for a company secretary or a company point of view, going to the penalty, we have seen in multiple cases where ROC does not have any option to reduce the penalty, right?
See,
Suresh, can you mute your this
yeah,
thing?
Monday
I,
I
Suresh,
think
గుర్తుపెట్టుకొని
those.
అది లాగిన్ అయ్యి ప్రింట్అవుట్ చేద్దాం.
I will mute.
నేను అక్కడ
You
లింక్
mute
అది
it.
ఓపెన్ చేసావా?
Yes,
Yeah. Yeah, Sandeep, see, wherever there is a discretion with respect to levying the fine or penalty, the concerned authority empowered to levy the fine or penalty, they have discretion. If they don't have discretion to levy, they have no option but to levy full penalty. So that's what in the proposal in this bill also, some of the sections where the consequences fine of up to rupees 1 lakh. So they are replacing with penalty of 1 lakh. That means
right.
no option to levy because they don't want to give this discretion, give the scope for the adjudicating authority to discuss, sit on those non-compliances and then adjudicate how much to levy penalty, blah blah. So rather, I think government said no discussion. Simply your duty is to levy. If they identify the non-compliance, if there is a non-compliance proved, you levy the penalty. Of course, if you are aggrieved by that, then there is a higher level authority in the form of regional director. We will entertain your application and he may consider your case based on your financials and based on the gravity or whether the application you are making is suo motu. So on these grounds, and they will the appellate
Right.
authority being here in this case regional director, he will he may reduce the penalty or confirm it or then
Right.
he completely remove the penalty.
Right. So, one more thing, does this amendment make us the disclosures are required to be like the forms which need to be filed are are any forms are getting reduced to get filed or
No,
forms are
we
getting
did.
increased?
See, more and more disclosure. Don't expect that forms are getting reduced. Forms may increase more also,
Okay.
increase more, and then you will see only in the through when the rules are notified under this section post this amendment of Act. No, so
Right.
the MCA has to come out with the rules to enable the substantial provisions of this proposed amendment. Then we'll realize whether any forms are getting
Understood.
reduced or consolidated.
Today it will get approved, sir. The effective date.
Hopefully, because the government's these are legislations are not much priority. So
Right.
they should, because they should do this. They should amend it. Let us hope.
Okay.
Except few as a practicing professionals, what we have to look at it as to this thing is that one major amendment they are trying to bring, which as a company secretary every year you will find a difficulty, is that obtaining the disclosure of directors on the first every year in the month of April or before
MBP 1.
Government Day. They are trying to dispense with that, and they said once you disclose, whenever there is a change, you seek a disclosure. Otherwise, you
Okay.
don't need to take it. So that is there in amendment.
Okay. Let's go, sir, one by one then.
One by one.
I have I have shared the screen.
Yeah,
Are you able to
run through each pages and then highlight it. So cost accountant, all of us know that now the institute name, they've changed it from cost and works accountant to cost accountant. So that is simply an amendment to give effect to that.
Okay.
Second, wait. The second amendment, finance layer. If you recall, the concept of finance layer is got amended in the Companies Act 2013 Act and enable the companies who are subsidiaries or associates or holding company of a foreign company in order to align the financial layer of Indian company with the financial layer of the
foreign company?
parent company or subsidiary of outside India. So on an application, then already used to permit to have the financial year of that of the parent company, which is a foreign company. But as long as the relation is existing is fine. But once the relation is dissociated and disconnected, and if the Indian company is no more associated with the foreign company in the form of subsidiary holding or whatever it is, and Indian company then obligated to follow the financial year of April to March. So if in such a scenario, we in fact we also come across where the companies which have chosen calendar year as a financial year, when they want to come back, there was no provision in the act. We used to go to regional director, and then regional director using his deeming powers. Yeah, when he has power to change the financial year, he has power to again bring back the financial year to April to March. So, but not to bring that now, that understanding was more legalized now in the form of this amendment. So this amendment enables those companies to come back from difference financial year to financial year of April to March. So this amendment effect of this
No
amendment
need to make an application to RD, you're saying?
you need to make an application.
No,
Okay.
no, no.
You need to
Earlier,
make an application.
Sandeep, there was a issue that even the RD office was finding problem to process the application.
Yeah.
And companies were also under different view that why should we make an application? We are following as per the act. So
Right.
now to bring that clarity, now they have made this provision.
Okay.
So now to what Ramna is saying, so you don't have freedom to come back, though Act says, because once you choose a different financial year with the approval of the central government, now you want to come back to the normal financial year. You have to make an application and come back.
Understood.
Yeah.
We'll move on, sir.
Yeah, go on. Yeah, next new definition, regional director definition was introduced under section 72, subsection 73A. So if you recall, if you see the whole Companies Act, nowhere the expression regional director was used except in section 12. Section 12, where it says that if case of the company wants to shift the registered office from one jurisdiction of RD to another jurisdiction of RD within the same state. If a particular state has more than one RD, in case you want to shift the registered office from one jurisdiction of RD to other RD jurisdiction, you have to make an application to RD. Except that mention of RD, nowhere the word RD was referred in the whole Companies Act. Moreover, regional director was not even defined. So maybe government thought that is a vacuum there. So they were trying to bring a definition of RD. But interestingly, here it says that regional director includes additional regional director, joint regional director, or deputy regional director. I am trying to see that because some of the sections where if the central government delegated power to RD, and only RD can take a decision. Only RD has power and authority to issue reports, like maybe section 12 case or any other case.
Any order.
Only RD has to sign it. In the absence of RD has no power to delegate to the subordinate officer. So now I think by this definition, I think in the absence of RD also, the RD can subdelegate this power to the next level officers. Because we have seen scenarios where some of the office of RD was not posted when the vacancy is created. It took a lot of time to come someone to fill the gap.
Somebody will come as an in charge.
So until someone comes, we had in fact Hyderabad RD. I think one point of time,
2 years back,
the Chennai RD used to come every week, every fortnight, and process
once in a week,
and go back, because the next level officer has no power to process those applications. So I think maybe we hope that this definition is trying in those direction to address those difficulties.
Understood.
Yeah,
it's a good move.
Definition, registered value was not defined, while the registered value provision is there under section 247. And I think they're trying to define the registered value. Simply say that registered value means a person who holds a certificate of registration granted under section 247. A lot of provisions were introduced under section 247, which we'll discuss maybe if not today's session, tomorrow. Next session we'll do that.
Okay. Small company.
Yeah. Next definition, the amendment is small company amendment, wherein if you see that today at present, small company means a company which is not a private, which is not a public company, and having a paid up share capital of up to 4 crores and turnover up to 40 crores. And government has enabling power up to increase this limit to 10 crores to 100 crores. Now government, I think, trying to feel that 10 crores, even 100 crores is small. So I think they were trying to bring more companies within this bracket, and they have taken the enabling provision by increasing the limit from 10 crores to 20 crores and then 100 crores to 200 crores. So government can any day can increase the limit of this 4 crores of paid up share capital and the turnover of 40 crores to up to 20 crores and then 200 crores vice versa. So with this, more and more companies will come under a small company category, and then they can enjoy the benefits of small company.
Right, sir.
Actually, they are trying to take the power from the act to the ministry itself, so that they can rise whenever depends
Whenever
upon
they
the
want.
situation. Whenever they want. But only one problem I'm seeing is, if this is made to maximum extent, already tier 2, tier 3 cities, our professionals are losing certification work and all.
Yeah.
So it will impact the profession.
Definitely, as Ramna was saying, I also watched that. So it is impacting. This is an impacting professions with respect to. But Ramna, I think we should here itself. I think these compliance certificates should continue for small companies.
Yeah, that in the proposal we are already representation we are giving that for small companies bring back that old compliance certificate.
Section 66.
Because all problems normally will come with small companies only.
Obviously,
Big companies anyway, they have professionals, they will guide.
They will guide. But even operation mismanagement cases comes in small companies. Nowadays, so most of the joint venture companies starts with being a small company, and then as they grow and the journey is fruitful, they continue, and then they grow big. But until then, regulation is required. Regulation is required. I don't know, maybe in the garb of trying to make doing business easy, living easy, they are trying to make them free from minimum reasonable regulatory restrictions. Next section amendment memorandum is only they are trying to bring. I said here. So which in the memorandum, one of the section if the company is incorporated by subsection, go to subsection 5A. So Sandeep, 5A. Yeah. Yeah. Now, I think with respect to the name, name here, if you obtain the name, it is found that name obtained by furnishing a wrong or incorrect information. Earlier liability is penalty which may extend to 1 lakh rupees. Now, that discretion of up to 1 lakh is removed, getting substituted with 50,000 rupees. That means no discretion, straight away 50,000 penalty.
Okay.
Yeah, next. Not a major change here. Yeah, here I see. I don't know what is they trying to bring it here. It says the self-declaration and affidavits by the professionals are not required for incorporating a company. So the class B, which has both these requirements of declaration from the professional and also declaration by persons named in the article, they are split into the B sub B class B was split into B and BA only. But only they're trying to say that the declaration from the persons named in the article as director, manager, secretary is required. And down they're trying they say that where a company engages in such profession. That means if the company does not engage in such profession, is it not required? But whereas if you see the previous existing section, that's a clause, any advocate or chartered accountant, cost accountant, or company secretary practice who is engaged. There also the provision of engaging is there, but we fail to understand what is the proposal that they are trying to bring it in.
So, for the purpose of incorporation, company secretary is not required, signature?
No, it is not.
Intention seems to be so.
The article
seems to be so. If you are not engaged in a professional, see, where professional, then you don't need only declaration from persons. But here, for the learning for the professional is that you may have to have a letter proposal in writing that you have been involved to engage in the formation of the company. And in some cases, what will happen? Professionals themselves will register companies, and once that is done, they'll hand over the companies to the main promoter, especially when the foreign parties are involved due to the various difficulties in terms of obtaining DSC, DIN, blah blah, and also the foreign exchange law restrictions there. So maybe I think in such cases they are trying to cover these professionals engaged there.
You want to add something, sir, Venkat sir, on incorporation of?
I just want to tell it earlier it was there in the old act, it was missing in the new act, so they have tried to brought it back so that the declaration of the advocates professionals also will work.
Sure,
Okay.
go to next. Yeah.
Anything on 12A? Yeah, certain classes.
Section 12A. So section 12A, they're trying to see, now we have seen the most important aspect in corporate functioning is communication. All communication, some of the communication statutory in nature, like nature, and then under there serious consequences also, that in case lack of communication, certain acts and activities of the board are found null and void. And likewise, the company communication. So they were, but companies have freedom to resort to what the mode of communication, whichever they choose to have that kind of communication. But now the government is trying to bring uniformity with respect to certain class or class of companies. It says that no, the communication shall happen only through email, only through
Okay.
email address or other mode of communication in such form that okay. Otherwise, no, I think they're trying to bring that communication is only through email, because now more or less most everybody has access to emails. Emails, at
Sir,
least mobile they
this
have.
communication is to the authority or
No,
stakeholder?
communication to the stakeholders. Mostly communication to stakeholders.
Okay.
So
So the
see,
amendment.
today, if you have to send a notice, you may send an email, you may send hard copy.
Right.
Notices you may print it. Listed companies, the enabling provisions are there. If you send email, it is fine, blah, blah, blah. But for unlisted companies, also there is no enabling provision. Then you can, like sometimes you have to give by hand, email, blah, blah. For set of companies, they're trying to bring uniformity in terms of communications.
Sandeep,
And
one more
also,
point.
one minute. And also for set of companies, they're trying to insist to have a website. So when there is a website, then every time you can maintain this communication store uploaded there, so people can refer there. Yeah, I'm done. Ramna, you just want to add something.
Yeah, just adding to it, earlier directors and these people now DR3 KYC, they used to file update their mail communicates and all. After Data Privacy Act has come, there is no requirement of putting public domain the directors' details and all. So now the company's details they are asking to put it and also intimate to authority, so that there will not be like a return back of notices issued by regulators, all that. So company has to give the changes of their email addresses also to the regulator by filing forms.
Yeah, especially when there is investor complaints are there, you don't have an authentic email recognized under the act. So now if you see subsection 2, it clearly says the details of website, email address, and other modes of communication, if any, then shall be intimated to the registrar in such form. That means you must necessarily intimate about the website address, email address to the registrar of companies, and then I think for all future correspondence and communication with the regulator, companies must use that email address.
Okay. But in case of the company, already we will be intimating through the email ID will be there in the master data index, right? And the regulatory authority will send all the communication to that email ID only.
True. There is no concept of master data either in the Rules and Companies Act. It is MCA under MCA portal. They are voluntarily there to bring that some standard data about the company, but we can't ipso facto take that email address as an official email address for correspondence. Today, if you have to service of notice to whom you have to serve, where at what address you have to serve. So you just taking address of the master data and serving it, but there is no legal basis for that email address. So by bringing this section, introducing this section 12A, they are trying to bring that authority to that email address.
So we will be seeing a new form for the purpose of intimation.
Yeah.
Generally, at the annual basis, we submit the
one time. I think they may say one time, because in the form of rules should come as and when they should furnish the details, and as and when there is a change also should furnish. This should be the, I think in these lines, I think we may expect some information to be furnished, because discharge of duty of a person who is sending a notice. The moment you see, if under Postal Act, if you see the moment you dispatched, it is deeming that it is reached within 48 hours or so. When such deeming provisions are there, and you would like to have that the whole process of communication communication more legalized, more systematic. So, and when you don't have which email address you should serve to the company, and which you have taken authentically, and which the company has declared that no, all communication you should send it to this email address. So it becomes more and more meaningful for the regulators to serve it.
Right.
Tomorrow, companies cannot say that no, this email is not an authentic email. We will long back see if you've seen some company secretaries' emails also were there, some personal directors' emails also were there, and they never bothered to change it. But of course, where is even difficulties in amending like master data. So rather going to that difficulties, they rather continue with that because they don't see the significance of this email.
But this
So
is
now that
already being implemented, right? This has
Madam,
already been
that is there in
implemented.
no, that is there
No,
as part of master data. Master data, you are giving email address, and
ma-
but nowhere you are declaring that no, this is my authentic email ID to which
No,
all
no,
your
no, no.
notices will be served.
Now when we are forming the company, in that itself, they're asking you to give a separate email ID for which the communication has to be sent. It is already there, part of SPICE form.
It's
It
there,
is
and
there.
at the same time, even in the annual
no,
basis, annual return also, we mention the email ID and the website address.
True,
So
true.
but whenever there is a change, we don't have an option. We have to wait for 1 year for filing the annual return.
Maybe that's one reason.
Sandeep, in
Second,
the master data what we are giving, majority of the companies are giving only the mail ID of the professionals or CFOs there. Now companies, as Madam said, at the time of incorporation, they are seeking now. And for that ID, that will be only dedicated ID of the company, not of any professional or any employee there.
maybe they're trying to more legalize, madam, this mode of communication.
Exactly. Yeah. That's what. So that's what they've already started implementing now. At least all the new incorporations are insisting on giving a separate email ID.
Email, and moreover, I think they're expected to bring some form that you need to file with register of companies.
Yeah. So in the new
Even
form,
changes,
maybe for all the
even for
existing ones, we may have to now give a new.
Definitely, madam. I think for all existing one, there must be one-time requirement.
Correct. Yes.
They are trying to bring across the board
Absolutely.
that all
Yes.
companies should
Yes.
furnish this email address website as an authentic email address. Because
Correct.
some of the disclosures that you need to put in website. Which website? Whether really website official, you have to you are declaring officially that no, this is my website. My
Correct.
complaints I should do that kind of thing.
Okay,
Yeah,
we'll move ahead.
So in continued this section 20, the service of document, in continuation to that, I think this amendment is also being proposed for such class of documents by such class or class of companies. And the prescribed to its members, like communication service of such documents to its members shall take place only through electronic mode. Ease of doing business, ease of living, instead of sending hard copies and blah blah. So they're trying to bring the electronic mode is mandatory.
But what happens if there is no email ID of the members of the service of the shareholders or stakeholders?
And also, if the member requests that I need it in a physical form, then
True.
Because
Actually,
there are many, even now, there are so
but it's
many
there.
email IDs not available.
It is there in the provision. Provided further that a member may request for the delivery of any document through a particular mode, which he shall.
They may say, madam, they may start with the listed companies, because unlisted companies, you have demat account, and then you might have email also there. Of course, yeah, there may be cases, the old cases where you may not have email address. Maybe if this provision is enforced, I think members is required to have email.
Correct.
yeah, it
Okay.
is to bring in line with the SEBI regulations that especially listed companies annual reports and all, they're sending electronic mode unless the shareholder demands for physical copy. Same thing will be implemented for all other companies also now.
Yeah.
Okay.
And next amendment, the section 24, no power of SEBI. It is a miss out. Actually, this already removed by virtue of, I think, Companies Amendment Act 2017. This was amended, deleted, but it is only miss out. So they're trying to correct this by bringing this amendment here.
Okay.
Nothing more. Not major. Yeah.
Section 26, matters to be stated in prospectus. Okay.
Yeah, I think that fine. They're trying to bring in to the penalty.
I'll read out, sir. If a prospectus is issued in a contravention of the provision of this section, the company and every person who is knowingly a part to the issue of such prospectus shall be liable to a penalty of 2 lakh rupees. Okay.
Yeah.
So,
So
penal
writing the
provision.
penalty of straight away 2 lakh rupees, there is no discussion here.
Okay.
Yeah. I think there is some chart back some queries. Just see, Sandeep.
Yeah.
Jagdish asked.
Jagdish asked it. Sir, if website is
Convert.
disclosed to registrar, then annual returns are also available on their website, which is till today small companies are sitting as a non-website in their board report. Yeah. Which small companies are stating as a no website in their board report. Yeah, I think, see, this website requirement and all, if you see, as per the Act, only for a certain set of class of companies, I don't think they'll insist this provision immediately for all the companies.
Because there are some companies, they have website but not functional.
They're not functional.
And if they are not functional, if you have a website, then it is mandatory to upload your annual return. But this is for a certain class, they have to mandatorily
have
a website.
We have to wait for the rules to come and see what kind of companies they are insisting to have this. Yeah, that's it.
Section 40. Nothing. Shall I move?
There's no major change here. This is a penal provision only.
Okay.
Not much there.
42.
Yeah, 42. I think if you recall, I think this is a miss out which they're trying to amend here. If you recall, even in the last session when we had that section 42 and 62 discussion where the heading still carries the word shares.
Right.
Now it has been substituted by securities.
Securities. Okay. Okay.
And now, another important thing is that if you see section 62 1A, the further issue of shares should be offered to the employees and to the employees who have been given ESOPs. They're trying to add another category of plans here that any other scheme linked to the value of share capital of the company. Cashless schemes. I think these are the broadly cashless schemes where so
that is in 62, na sir?
62.
That is in 60. Yeah.
62. Here, this is what? Even more or less they're trying to bring here. 42 also this provision is there.
Okay. 42 10.
If you see there is a mentioning of scheme of employee stock option scheme. Wherever scheme of employee stock option scheme comes into play, they are including not only ESOP scheme, apart from that, any other scheme which is linked to the value of the share capital of the company.
Okay. Sir, 42 subsection 10, I think this is with respect to penal provision, right? What is the changes here? Let me see subsection 10. Subsection 10 says,
which may
extend.
That means the discretion they are removing.
So that, the amount raised through private placement or 2 crore. Earlier it was there.
Here we have to read it not that way. Say the consequence of, in case private placement is done non-compliance to the provisions of section 42, the consequence is that the penalty of up to amount which you raised, which you raised in the private placement,
or 2 crores,
whichever is less. Now that up to the authority who is levying, he can levy maximum 2 crores.
Okay.
You see, you go back to subsection 6, what it says, whichever is higher, right?
10. It says whichever is lower.
Whichever is lower.
Right.
Which may extend to amount raised through private placement. Here, see, here there is a discussion to what is that? It is a
equivalent to. It says equivalent.
No, don't write. Now I'm saying is penalty. What is this? You have to refer controls in this penalty. So penalty, let us say if you have raised two scenarios. If you have raised less than, let us say 5 crores.
Okay.
Then penalty is limited to 2 crores.
2 crore, yes.
If you have raised penalty, assuming that if they raise less than 2 crore, 1 crore you raised it, and the ROC may levy 50 lakhs.
Right.
ROC may levy 50 lakhs or 2 crores, whichever is lower. That means ROC, the discretion of ROC lies here with respect to fixing the penalty in case
yes. So this
amount is less than 2 crores. Okay. But here the discretion they are removing. You say if whatever is the amount you raise, that much amount is the penalty, or 2 crores, whichever is lower.
So this is a practical thing which we have faced, I think, Rashida madam. In
Yeah,
Seed
yeah.
Habit we have faced. So the thing is that it says to the extent. So we try to convince the ROC that, sir, it says that to the extent of. So you have a power, you reduce it. So he's saying, I don't have any power. So we were specifying this particular point that it states its extent to the extent. So you have the power. So he was like, no. So I think with this amendment,
Yeah,
it has
so
been
this
clarified.
particular alimony they have now removed. They're saying equivalent to.
Madam, it is not anomaly. There is a discussion clearly given. He doesn't want to exercise that.
No, he says that there is a clear direction from the ministry that not to, you have to do it. So now the ministry has put this so that, there is no.
Maybe thinking of ministry, now they are legalized.
So there is an internal direction to all the ROCs, adjudication officers, that they cannot use any discretion. Whatever is the maximum penalty, they have to charge. So now, therefore, they have now amended all this because this was their internal direction. So now they put it in the act itself.
True. Right.
Yeah. I'll move forward.
43A. Next is the most important section.
Is it a new section? Oh, it's a new section.
43A.
This is all related to IFSCs.
All related to IFSC.
So everything, all the new sections wherein you say IFSC, we can now issue shares in foreign currency.
Foreign currency. Yeah, see, the foreign currency. Those
Sir, I believe IFSC is a very huge subject. So are we?
We will have a separate discussion on that.
We will have a separate discussion, but
or briefly you can tell. Yeah.
Sandeep, I'll just bring a few 3-4 points just for knowledge. What was the amendment basically? So those companies IFSC that they need to incorporate the companies with the capital issued only in permitted currency, foreign currency. And second, for all the existing companies, they should convert them in their capital from INR to permitted foreign currency. Third, in case such company wants to issue,
they may convert. They have
wait. That may is there. May why the purpose of may is that they can come back. If you see subsequent down, provided further that company there only.
Okay.
Provided further that company referred to in the first proviso shall not be permitted to issue any share capital without converting its share capital into permitted foreign currency.
Okay.
One side mandatory that no, you can in case you want to incorporate, you can incorporate with the capital issued only in foreign currency. Of course, in case as long as you don't want to issue any further share capital, you can continue with INR. But in case you want to issue raise your capital, first you need to convert your existing capital into permitted foreign currency, and then only you can raise the capital. One. Second, another interesting thing, they have to maintain records in foreign currency, books of accounts and other relevant records. See, shall prepare and maintain its books of accounts and other relevant books and papers, financial statement, and all of the records in permitted foreign currency. Okay, but if they can present them in INR, provided if it is permitted by IFSC center. It's like another ROC. It's like an ROC for those companies. IFSC and ROC there. While you maintain books of accounts in permitted foreign currency, you can present them. Maybe present, I don't know what is the intention of to whom they want to present and who are the consumers of that. We don't know. They can permit only presenting them in INR.
Presenting and record.
Presenting means presenting before the meetings, right? General meetings.
No, it says maybe present, maybe, okay.
They present such books of accounts and other. See, the above subsection 2 says that shall prepare and maintain. You must necessarily prepare and maintain everything foreign currency. But such company may present such books, but presenting to whom?
Ramki,
Ramana.
It is for the purpose of presenting the financial statements to the income tax departments. They need that anyway tax, anything is not there. Just they are seeking the information to be in the currencies so that they will understand how much is there. This is only for information sake for the purpose of government.
But
Correct.
Rama, if that was the intention, like income tax requires them to present it only in Indian currency, but they're putting the condition that no, it should be permitted by FSA. That means every companies who are listed there for submitting to income tax, they should take permission. You see, provided that if the IFSC authority permits such company may present, then it becomes very difficult. No, every time every company should take them.
So Ramki, in the best case would be that to publish it in both the currencies, and in the foreign currency and Indian currency.
Obviously. And second,
I mean, you have to have it in both currencies. While you're doing it, you're publishing it in the foreign currency as well as in the Indian. Then you don't require, because you're not exclusively publishing it in Indian rupees. Because what they're trying to say is that the penalties, fines and all have to be paid in rupees only, INR.
Yeah,
we cannot pay in foreign.
Make no sense there, madam. Make no sense, because if they have to pay foreign currency, why unnecessarily waste foreign currency?
Exactly. So therefore, normally in this case, what will happen is the companies will have to present it in both the currencies simultaneously.
But you see, subsection 3, the central government may, in such manner as been prescribed, require that a company referred in subsection 1 shall use permitted foreign currency for the purpose of filing, submitting, and delivering any document.
Yeah, that's what I'm saying. So it will be like you submit it. We'll submit in both we will prepare it in both currencies. That would be that would be the advice we would give, that better do it in both the currencies.
True.
Shall we move on?
Yeah.
We can move on.
Section 62, any major changes?
No major change, that except that apart from ESOPs, no equity value linked
same thing like 42.
Same thing, value linked scheme. Yeah. Other than this, no change here.
Okay. I'll move ahead.
Yeah.
Buyback.
Go back. Next, there is an amendment in the buyback of securities. What the amendment proposes is that basically for such.
Shall I read it first, sir? Shall I read it out so that everybody can connect it?
Okay.
So the changes is provided that in case of such class or classes of companies as may be prescribed, the buyback may be up to such percentage of aggregate of paid up capital and free reserves as may be prescribed. Provided that in respect of the buyback of the equity shares in any financial year, the reference to 25% or such other percent as the case may be in this clause shall be construed with respect to the total paid up capital in that financial year.
Yeah. So, see, if you recall the existing provision which says that up to 10% board approved and then up to 25% with special resolution. And this amendment contemplates that for such class or class of companies as may be notified by the central government, buyback may be up to such percentage. That can be less than 25. It can be more than 25.
Okay.
More than 25. So that is an implication. So unless maybe the operating provision should come in the form of regulation, then we'll understand more.
Okay.
Second, and again.
And buyback only.
One more amendment is that for such class of companies, they can do 2 buybacks.
Earlier it was only 1 year, 1 buyback, right? During the financial year.
One buyback. Now they can do 2 buybacks with a period of 1 year, reckoned from the date of closure of previous buyback. If second buyback during the year is not made earlier than 6 months, that means the gap should be 6 months.
Okay.
Gap should be 6 months. As long as after 6 months of the first buyback, you can do 1 more buyback within the same financial year.
Okay. Irrespective of board or general.
Irrespective of board or general.
There is no changes in 66, sir? Reduction of capital?
No.
Because nowadays RDs and NCLTs are rejecting the reduction of capital with respect to share premium account, utilization of share premium account. And they are also sending it to income tax also. Bangalore NCLT has rejected twice. 2 times recently.
For using share premium.
Yes, and 3 of the companies are under NCLAT. They have, I think somebody should have raised it.
But there is no amendment proposed.
Yeah. Okay.
Wherever affidavit, a declaration through an affidavit, they are removing that affidavit. Self-declaration. That's what is this government motto. Do a self-declaration. So that they are removing that.
So, okay. Affidavit is replaced by self-declaration.
Declaration. Oh. And verifiable affidavit is not required.
In all the sections, sir?
No, here only. This are
Here,
mostly all the sections. And wherever still that affidavit is there, even in the incorporation section, earlier affidavit was there, that removed it, and now wherever still that affidavit requirement still remained in the company side, they're trying to remove that.
There is one in 230 also where you have to take a
No,
consent from the creditors in form of an affidavit. It says.
Affidavit, affidavit. Maybe there, I think they will not touch that.
We'll see.
Let me see that when section comes.
Okay. Shall I move ahead?
Move
68
ahead,
is over.
Go on.
Liable
Again,
for
this
the
penal
penalty.
provision, as standard understanding is that wherever fine is there, they convert it into penalty, and wherever the discretion is there to ROC or authority, they're trying to remove the discretion. You see,
So
the
is
highlighted portion, it shall be liable
okay.
to penalty of 25 lakh rupees. Also, you see the down, who is in default shall be liable to penalty of 5 lakh rupees. So that means this completely they're removing the discretion to the adjudicating, like this ROC.
Oh, is it reduced or what is it?
No,
Penalty, I understand.
they increase penalties.
Increase the penalty.
A
Increase
few
the
cases
penalty and it's they replace it with penalty.
They're fixing the
from fine.
fixed amount.
Okay.
It is a fixed amount, not a like cap.
So since all are under e-adjudication, this will fall under e-adjudication. ROC does not have any power of adjudicating the adjudicating the penalty. So the penalty will be
adjudicating
fixed.
violation. First, you have to adjudicate whether the violation occurred or not. Once he determines that, then what follows is then levying a penalty. What is prescribed? As far as levying penalty is concerned, he has no discretion.
It looks like a straight through process where
straight through only. No, levying quantum of penalty is straight through, but determining the non-compliance is again you have to adjudicate. No.
Right.
Sorry. Due to register charges, if you see the existing provision that all the companies which have created a charge on assets of the company has to file the particulars with the register of company within 30 days and with additional fee within 60 days. Now, for such class of companies, they are extending this period up to 120 days. This is the only change.
Earlier also it was 120. To 60.
Creation is only 30 and 60 days.
Right.
And now they are extending to 120 days only for such class of companies.
Okay. Section 88, register of members.
Section 88 is a no comeback provision. Comeback provision means it was there in the 56 Act and it is missed out in 2013 Act. Like no notice. Names of trustee cannot be entered the register of members of the company. That was the provision. So it is only comeback provision.
No notice of any trust,
whether express or implied or constructive, shall be entered in the register of members or debenture holders maintained under subsection 1.
What is it, sir?
Implication is that if the shares are trustee, over the person in whose name shares are held, his name is entered in the register of members of the
register of members.
Not more than that.
Right.
That's all.
Sandeep, it is only that the company will recognize registered holder only as its members. Beneficial owners will be in the form of MGT 4 and 5. That is 89 compliance is different aspect. But earlier act also it was there. They want to bring in the same line. There was no clarity in the new act. Now they want to give clarity that in the register of members maintained by company, no notice of trust can be entered. Only registered owner will be entered as a shareholder name.
Yeah. See, when a similar provision was there in 1956 Act and it is missed out, so that gives rise to some kind of confusion that is it an intentionally dropped provision or not. So in order to bring that clarity, now the law is that as Ramana said, only registered member name should be entered, and if there is a beneficial owner, if there is a trust, then that that beneficial declarations and disclosures will follow.
Understood.
Yeah.
Section 96, sir, annual general meeting. 19
is the most welcome provision. Basically, now that more or less all companies are being allowed to have the AGMs conducted in video conferencing mode post-COVID, and they've continued to allow them. So now they're bringing in the statute book by saying that the companies can hold the AGMs either physically or through video conferencing or audiovisual mode, either wholly or partly.
Okay.
So now you're allowed to do that, but provided once in every 3 years, you must have a meeting physically conducted. This is the provision.
Now we are just getting some of the clarifications are needed from the ministry when they say once in 3 years up to till from the COVID days by virtue of notification we have been conducting in virtual mode. So that 3 years bracket will start after the law emerge, or whether I have to take the count for the last 3 years the mode I have convened. That may be the issues which will come up for discussion. So in the rules they may clarify that.
I think it will be from the effective date only, no, sir? No?
No, that is our thought always, but
Okay,
there is always chance for the
But
issues.
okay. I think there is
once in
there's a
every
loop.
3 years. See, once in every 3 years always is a contentious question. Like no, once in every 3 years means calendar years. Block of that 3 years you have to take. Or is it 3 financial years you have to take? So these questions will emerge. Definitely, these questions will emerge. Maybe I think it is more meaningful for us to discuss once the rules comes. If the rules clarifies that what to give the intention of the legislature, then I think that's fine. Otherwise, we have to sit down and interpret that. So next, second is that if the number of members required to requisition a meeting under section 100 to have the meeting in hybrid mode, company is obligated to have the meeting in hybrid mode.
But instead of physical mode, it should have mentioned hybrid mode only during this 3 years, I believe.
No. See, hybrid mode is mandatory. Once in 3 years, physical is there. But I only confusion here is that, see, let us say if the members requires, like provided that if the number of members referred to in subsection 2 of section 100, section 100 deals with the requisitionist meeting.
Right.
Requisition the meeting to be held in hybrid mode. Meeting means all meetings are a particular meeting. The company shall hold the meeting in such mode. If they require that, no, you don't have option. You must necessarily hold the meetings in hybrid mode. So is it binding on the company to have the meetings conducted only in hybrid mode? Because that comes as a first proviso. The second proviso only says that once in 3 years, physical mode.
No, here the question comes fundamentally if after I give the 25 days notice, if that fellow, like earlier we used to have that, in the board meeting and also well in advance, if they ask for hybrid, then we can facilitate. If they just come and ask for 2 days before, then the company will not be in a position to provide that facility. So in the rules that should come, that how many days before they should extend that requisition.
That is one. And second, the enabling provision of holding meeting in physical mode. Say physical mode. Why people would choose to have physical mode? 1 minute, Sandeep.
Yeah.
Why members may choose to like companies choose to have a meeting in physical mode to avoid members' participation. Some of the companies resort to that kind of practices because they don't want to have more members participation in the meeting. So they'll conduct somewhere in the district office, which is away from the city in physical mode and all. But so with this option of holding available to the company to have a meeting held in physical mode gets obviated by if the members request for a holding meeting in hybrid mode. Because that hybrid mode option is coming first, then the physical mode option is coming next to the.
No. I think what they are trying to say here is basically this is with respect to meetings called by requisition by the shareholders. So right now,
that is section 100.
No, madam, no. He is only referring that about that 1/10 number. Unnecessarily, he is mentioning 100 section. How much number is required? The number of members for requisition meeting. Same number should demand for hybrid. That is what hybrid they want to say here.
Okay, got it. Yeah.
No, madam, see, main provision says that companies are free to hold meeting physical, video conferencing. Video conferencing. And the members can request to have the hybrid mode. That means physical as well as hybrid mode. Third, it says company have an option to have only in physical mode once in 3 years.
Correct.
So this option available to the companies gets discounted if the members request for a hybrid mode, and if that request is every meeting has to do, or can they request that no, all meetings should be held in hybrid mode? So if that option is
Understood.
exercised, the physical mode option available to the company will go up.
Correct. Got it. Understood.
Yeah. Sandeep, next.
But section 100 is for extraordinary general meeting.
No,
not for
EGM, but see, there is a number of members required for.
He's just talking about
referring
number
to
of
the
members, 1/10. Yeah.
Okay.
Section 1/10.
1/10.
Go to
No,
next.
but here, Ramakrishna question here is that when can they demand?
Maybe, madam, see, so I'll hold the when can they demand? It should come in the form of rules, madam.
It will come in the form of rules.
Rules are, because it is not a request to conduct a meeting, convene a meeting. It is request to have a meeting in a particular mode.
Hybrid mode.
That's what. So now, like Ramana said, if they request just 2 days before the meeting, should we adhere to that request or not?
Definitely, that will be difficult.
Shall is used, ma'am. Shall is given there. Shall hold a meeting in such mode.
No, true.
So
that's what I'm saying.
I will hold it, but Bhavani, but at least companies should have some breathing time, no? To make
Right. I agree. That cushion should be there. One more thing. Third, if you see first paragraph, it talks about AGM. First provision talks about members requisition meeting. And if you see last condition, it talks about AGM. So first subsection 3 and second provision are talking about AGM, Ramakrishna.
No, all
but the first provision is only for the purpose of referring
Bhavani,
section 100.
Subsection
Bhavani,
3
Bhavani,
is
he just
only.
Right. Got it. This is only number.
Reference to the number of members required to demand that hybrid mode.
Even I got confused earlier. It's saying 100 is with respect to EGM. So
Correct.
later on again,
Yeah, taken away by just giving the reference. Yeah.
Even section 100 also amended. We will discuss that. Next, Sandeep, next go.
Yeah. Section 99, sir. Punishment for default compliance.
Punishment basically here is that, see, 96 to 98. If you see 97, this existing section says that if any default is made in holding a meeting of company in accordance with section 96 or 97 and 98. In fact, 97 and 98 has no provision which is obligate, which requiring casting certain duties on the company. It simply talks about powers of the tribunal to call for the meeting. So that is irrelevant reference as to assuming some default of which the company may occur. Section 97.
What are the changes made, sir? It says 96 and 98.
I will tell you. See, they are trying to remove reference of section 97 and 98(1).
Okay.
Sandeep, actually, when the NCLT orders for convening the meeting in our O&M matters, then this provision will come into
force. Then section 97 will come.
Yeah, but since it is already treated as contempt of the court and consequences will follow, they don't want to give any connect here. So they are rectifying and removing that relevance here.
Yeah, meeting called by tribunal. Meeting called by, like 97 says power of the tribunal to call for AGM, and 98 power of the tribunal to call meetings of members. So when obviously, as Ramana said, when such power is exercised by the tribunal, there is consequences will follow in case the meeting is not conducted. So apart from that, now this section also says that the consequences of section 99 also will follow in case if there is a deviation to the orders of the tribunal. So it's a double jeopardy, right? It is double jeopardy. So when the court has power to enforce in the form of contempt for their orders, why do you again penalize? Again, as a part of ease of doing business. So let us not.
So the red one which is highlighted, section 97 and 98 has been deleted. What you're trying to say?
That's what I'm saying.
Yes.
Okay.
That is
only section 96 non-compliance fall under 99.
Correct.
That's all.
Move forward.
Section 100. Anything new?
Same. A company may hold its EGM. Same physical through video conferencing, audio, visual means either only blah blah blah. And then now that discussion which we did comes here. Provided there is the number of members. Request a meeting to be held in hybrid mode. Companies shall hold the meeting in such mode.
Okay.
Yeah.
This is
Okay,
120.
it's all continuity.
Okay.
This is what
Continuity,
notice of meeting.
101.
Notice of meeting, we'll call begins, like, no, yeah. See, now, when the members can, companies can call these meetings with the notice of 7 days, provided that EGM conducted wholly through video conferencing or audio-visual means may be called by giving notice of not less than 7 days or such other period and in such other manner as may prescribed.
So the notice period has been reduced from 21 to 7 days.
At present, we had a shorter notice provision. For shorter notice provision, you have to comply 95% consent, blah, blah, blah.
Right.
Right. Now, it is difficult to get a 95% consent of the members for holding meetings of AGM at shorter notice or EGM at shorter notice. For AGM at shorter notice, 95% is required. EGM also 90% consent of the members is required. So that is very difficult. So they said, okay, if they are holding a meeting at video conferencing mode or audiovisual mode, 7 days is enough.
7 days is enough. 21 days is not required.
Not required.
So even you can go for shorter notice also less than 7 days.
No. Shorter notice provision, they retained it. Even less than 7 days you can go. In case, see, they already reduced from burden of taking consent from everybody for 7 days. Further shorter notice you want, then you take consents. So
in short, for the EGM meetings, the notice period is now 7 days. Earlier it was 21 days, now it is 7 days.
Provided EGM held in VC mode.
VC mode, not even hybrid mode.
Not even hybrid.
Okay.
No, hybrid only, no, not even hybrid, not hybrid mode.
Okay.
He said no, wholly through VC or audiovisual means, not hybrid.
Okay. Wholly, yes.
Understood. So next.
We'll move on. Section 124, sir, with respect to unpaid dividend.
It's only clarify, the provision. It's a transfer of unpaid dividend along with the dividend which has not been paid or claimed under such shares, claimed where such shares have been transferred by the company shall be inserted. It's only transfer of unpaid dividend or the dividend on the shares which are not claimed. Those dividend
transferred by the company under subsection shall be inserted. Okay, along with any dividend which has not been paid or claimed, where such shares has been but it's already there, na? In practice we are doing.
Is already there. They are trying to clarify.
Okay.
Yeah.
We'll move ahead.
Second amendment, they are trying to say that the Investor Education Protection Fund authority they are adding. I don't know what is the authority. See, one side they are using the word fund, you transfer to fund. Now they are saying transfer to authority.
Authority means IEPF, no sir?
Investor Education Protection Fund.
Okay,
that is different. Authority is different.
Okay.
So now I think they are trying to merge both together and say it's only authority. Who will maintain that fund?
So the word fund has been replaced with authority.
No. After the fund, the word authority.
Fund authority. Okay. IEPF authority.
IEPF authority.
Okay. Anything in 125? Something is omitted.
125, not major. Not major.
I'll move ahead.
Not major. Only this, the clause, the amounts in respect of such shares buyback, back or extinguished shall also be transferred. This is all more probable, not major.
I'll move ahead.
Application. Go ahead.
128, anything with respect to the accounts?
Books of account. Be liable to penalty 5 lakhs. Yeah, same, no, all fixing the quantum rather giving discretion.
Okay. So fine became penalty. Punishable become penalty.
Penalty, and then that is fixed amount. Fixed amount. Okay.
Okay. Section 131. 131 is a revision of financial statements and the board report before
NCLT. There is a 3 preceding finance layers. Instead of that, they are more of a clarificatory.
Okay.
This is important.
Yeah,
just one thing.
I think we will skip in today's discussion because itself is another big, because they are trying to bring more and more provisions for NFRA and then complete functioning of NFRA, the authority, the powers, or they are trying to bring in the part of substance in the Companies Act itself. So we will discuss.
We'll skip NFRA then.
I will skip this NFRA now. And in there, just for go on. You skip. I'm just they're giving powers. Even the civil code will have power to entertain the matters which falls within the purview of NFRA. This all, you go ahead. remove. This is all part of NFRA.
Registration details of auditor, section 132.
So auditor, see, wherever there is an investigation being conducted by the NFRA, such companies, in case they want to appoint, in case for the appointment of auditor, such company, they have to inform to NFRA. That is the requirement. So the complete provision, set of provisions are there. We will have a separate session for them.
Okay, sir. Section 134, board's report.
Board's report, there are two, I think they're trying to bring one some more disclosure requirement. It says that, you know, wherever there is an observation, comments of the auditor on financial transactions. If you see subsection F, what explanation or comments by the board on every qualification, reservation, or adverse remarks or disclaimers made by the auditor in his report. It is very general. If there is observations or comments by the auditor on financial transactions, specific transactions, if they are made observation, then you have to give an explanation. Board has to give an explanation in the board's report.
Every observation on comments of the auditor on financial transactions. Okay.
Yeah, that's all.
Any addition is there? So that
this is an addition only. FA is an addition only.
Okay.
But Ramakrishna, earlier also any adverse remark or reservation qualification, whether it is falling under this category or any category, in general category also, you have to respond to it, right?
Obviously,
I do not know why.
More elaboration, Bhavani, more elaboration. See, if auditor has to give a qualification or remarks, he has to give a qualification remark on each and every transaction, specific transaction. Like allotment is there, he may give. Loans
maybe a different grouping they are giving, that's it.
It's not grouping, he's trying to bring more explicit.
So,
but this is an addition to existing one, na?
He's saying it's existing, like addition, like FA, but it is already covered. No?
Correct. It is
already covered. So, in case if there is a qualification, it will fall under F.
No. I think I'll maybe what could be the reason? See, auditor role is to confine to CARO report, the scope given under CARO. Remaining is discussion. More or less, he has no problem. But now it says, auditor, if a particular specific transaction which is not part of CARO, in case if he is giving observations, maybe you have to give disclosure.
Right.
But maybe we have to
understood. So, earlier also we used to divide this into maybe
with the scope of auditor with under CARO, we have to read that and maybe I understand the implication.
So one additional disclosure is there in the director's report in case if it is a financial transaction.
Financial transactions are matters, matters which have adverse effect.
Okay.
The presumption, adverse effect on the functioning of the company. So this is more important.
Okay.
That means auditor has to comment that this particular transaction has adverse effect on the functioning of the company.
Okay. Sandeep, can you just go up again?
No.
What you're saying is that the explanation or comments by the board on every observation or comment of the auditor. So here there are two things. One is in this. So explanation or comment by the board on every qualification, reservation or adverse remark. So this is first what F says is only qualification, reservation or adverse remark. And FA does not, what it says is that explanation.
Adverse remark and disclaimer also.
By the board on every observation or comment. It's not necessarily qualification, but if there is any other comment or observation, which has an adverse, so it may not be qualified. But
even observations and comments. Yes.
Comments.
Correct.
So this is a new addition.
Yeah, so which says that it's not necessary only, so we only look for qualifications or this thing. Here we have to see what is comment or observation which may have an adverse impact on the financials, then the board has to give a explanation for that also. So it's a very different thing what they're giving.
Yes, madam.
So like for example, they may say that there may be a comment that the company has delayed in filing the, or there has been delay in giving the statutory dues. Now this is a comment and observation, not a qualification. But this observation, now the directors will have to explain why there was a delay.
No, but at the same time, it says that on the financial transactions. So filing maybe delay or financial transactions, there should be some transaction maybe with other
Yeah, so
party
if they
or a
have not
related
paid the
party.
statutory dues within
Or
the
maybe
time frame, but there is a delay in payment of statutory dues, like there is a delay of 2 months, 3 months in filing the statutory dues. This is a comment, this is an observation.
Madam,
It's not a qualification.
Madam, more so, assuming that in case of a group company structure, where intercorporate loans and
Yes,
investments, like you made a decision. Let us you are sitting with like infrastructure company sitting with huge funds, let us say, and they invest into another company, subsidiary companies, and subsidiary
correct.
company has another set of promoter themselves around 45% of the promoters, and they invested,
Correct.
and that such investment has no basically kind of trying to know fund routing. If the auditor feels
Yeah,
that
so
that
whatever
finance
it
is
has an adverse effect on the functioning of the company, obviously this is an
true,
adverse effect. So
adverse
it
effect.
may not be a qualification, but it is a comment by the auditor. We have to also respond to
Yeah.
that. That's all.
Madam,
Yeah.
So
I recall some of the companies insist auditors not to give an adverse remark. In fact, now I could recollect after you said. So instead giving that as an adverse remark, they were insisting auditors to give us an observation so that
No,
they need
Correct.
not respond. So I think
but
this
Correct.
lacuna is being fixed with this. At least,
Correct.
they have expanded this, right?
no,
Right. I
even
agree.
right.
Yeah.
I think we can move it. So
yeah,
one addition is there in the director's report for all the company secretaries. So if we have to mention that, disclose that, even though if it is not there, so the
yeah.
auditor has not made any comment or observation on the financial transactions which are adverse effect, something like that.
No, not only qualification, reservation, adverse remarks or disclaimers, also comment, observations and comments made by the auditor also requires explanation by the board.
Because but if you see the auditor's report, it doesn't specifically say that whether it is an observation or a comment. Opinion, whether it is a qualified or non-qualified,
No,
there
no, no,
his
no. In
points
the
will be
Kano
there.
report, there are observations.
There are observations, but
Yes.
comments you don't know. So whatever he mentions, any comment on the financial transaction that need to be disclosed here.
They have to be explained.
Explain, reply.
Maybe scenario just to take an example. Let in case company has subsidiary which is a bleeding, but it has a long gestation project, and if the holding company continues to fund that, and there is no guarantee that that investment and funding to subsidiaries coming back. So which might if the auditor feels that it will have an adverse impact in case that subsidiary could not revive, could not repay back. So that kind of scenarios also.
Right.
Sure. Go to next.
Okay. There is one more addition. It's in PA.
It says that you have to give the composition of the audit committee, the board's report, composition of the audit committee, where the board has not accepted any recommendation of the audit committee. A statement aligned with the reason therefore.
Okay, where the board has not.
I don't know. Composition of the audit committee anyhow you disclose in somewhere in the director's report.
Maybe some incidents must have happened. We have not come across. We don't know.
Might be.
Okay. One question I need to want to ask in the board's report, there is a disclosure required in this particular case, PA. If it is not applicable to me, I should specifically mention that it is not applicable to, right? Even though because that's a new disclosure, right?
Yeah.
I'll move ahead.
Yeah.
Section 135, corporate social responsibility.
Yeah, 135, the limit of obligation to spend, they're proposing to increase from 5 crores to 10 crores or such other, some has been prescribed. So earlier it is fixed amount of 5 crores profit is mandatory. Now, increase in 10 crores or government power to increase more further.
No, it's good because anyway, people are struggling with 5 crores itself. People are not having funds to pay.
Not having funds. Yes.
So this is a welcome change for the companies.
Welcome change. Yes.
Relaxation to companies.
That unspent amount from transfer to that fund from 30 days to 90 days, I think we increased.
There was one more thing, no, sir, with respect to CSR committee has been
a CSR committee, CSR committee requirement also. For committee requirement, like say if CSR amount to be spent is 50 lakhs, you need to have a CSR committee. But that limit they are increasing from 50 lakhs to 1 crore rupees
1
or
crore.
such amount, higher amount as been prescribed. So amount to be spent is 1 crore and above only, you need to have a CSR committee.
Okay.
Earlier it is 50 lakhs.
What is this 30 days, sir? Within a period of 30 days? Company
Like,
within a period of
if
30
you
days.
see, go back, come to section, the transfer of funds, subsection 6.
Transfer of funds to the government.
Government, no, the 30 days is there, no?
Is there?
Any amount remaining
Yeah.
unspent
Now we have to.
shall be transferred by the company within the period of 30 days from the end of the financial year, right?
So now it is 90 days. We have
90
6 months.
So you have 3 months.
90 days, 3 months.
3 months.
Yeah,
Any
yeah.
amount remaining unspent under subsection 5 pursuant in an ongoing project, fulfilling such conditions as been prescribed, undertaken by a company in pursuance of its CSR policy shall be transferred by the company within a period of 30 days. Like ongoing projects, no? You in case of ongoing project.
No, this is okay. Into your special account, you can now transfer within 90
same
days.
account only. See, in an
Special
ongoing
account.
project, the project may span more than 1 year, right? So amount allocated required to spend, you may not spend that year.
Right.
So
earlier it was 30 days, now it is 90 days.
90 days. Come down.
In subsection 5 also there is some change, sir. Unspent amount under subsection 5 shall be
amount remaining unspent, they replace the text phrase with the unspent amount. That's all. You see, there only you read it. It says that for the words, brackets, and figures, amount remaining unspent, that was replaced with unspent amount.
Okay.
That's all.
So three major changes in CSR. Threshold limit, 90 days.
to 90 days, threshold limit, and then
CSR committee
constitution.
Okay.
Come down. Yeah, go. So
141. Anything in the auditor's report? Appointment of auditor?
Come down is there.
No, I think it's up now. 139, appointment of auditor.
Yeah, come down.
Okay.
Come down. What is that? The amendment we are putting in the right side. Wherever there is go there up till. Here it says which class of company which fulfills such conditions as shall not be required to appoint auditors under this chapter.
Oh, okay.
So there sometime back, if you recall, there is discussion about the non-requirement of statutory audit.
Okay.
So they may say you don't need to have an auditor.
Okay.
See, subsection what is the section 129, right? Appointment of auditor.
139.
139. See what section says.
This really impacts auditors, no?
Impacts auditor. Go back to Sandeep. 139, just read out first provision.
No. It means that certain class of companies may not require. They will say, okay, companies having turnover of less than 1 crore, 2 crores. Need not be in line with LLP. Like LLP says 40 lakhs, right?
Yeah.
Absolutely.
Appointment they may dispense with. They simply say you get accounts. I don't know. We have to see how does.
Okay. I think
this discussion was there quite long time in the CLC report also. For a small set of companies, you don't need to have an appointment.
I think this is specifically to boost
like
up the
OPC,
startups and all.
one-person company and all of those things probably.
OPC, blah.
To boost up startups and small companies.
Ease of doing and living. Now they're kind ease of living the companies.
Yeah. Section 141. 141 is the eligibility, qualification, and disqualification of auditors.
You read the highlighted one.
Provided further that every partner of the firm shall be a person who has been registered with the statutory institute or body established under a law in India having powers of such registration.
Yeah.
This is for the purpose of auditor.
This is basically
This
like
is for
multidisciplinary auditing
firms.
Today,
so every partner of the multidisciplinary firm must be registered with some statutory authority. Like
today,
ICSI, ICAI.
It can be chartered engineer, it can be lawyer, it can be cost accountant, company secretary, it can be doctor, professional. So who are professional bodies are institution that basically multidisciplinary.
You are saying multiple professions can form this thing.
Indirectly enabling. Say they are trying to bring that, no, like secretarial audit and statutory audit can be conducted by not by individual, by the firm itself. Now we'll discuss that section 204, where it says that you can appoint the firm itself as a secretarial auditor, provided that firm must have the partners who are registered with any of the statutory institute or body. So we will discuss further that. Now what it's trying to say, when multidisciplinary that partner must be registered with at least one of any of the institute.
Every partner of the firm has to be registered. If
but
there is any partner,
is it not there earlier?
No.
Multidisciplinary,
no. And
so CA and CS was not there. If there is a practicing company secretary firm, this will be CS related only, or CA. So there was no firm where multiple professionals come together and create.
Today, under insolvency, the IBBI is recognizing IPE, insolvency professional entities. So insolvency professional entities can be appointed as insolvency professional, as resolution, as an IRP and RP. But their majority partner should be IPs. Majority partner should be IPs. Today we have some IPs where partners are their spouses who are not IPs. Not even any other qualifications. So IPs are permitted today. So
Ramakrishna, just recheck the clause. I don't think it is calling for multidisciplinary, because if you see
the calling, Bonnie, it's not indirectly enabling. It's enabling.
No. That's what I'm saying. Just go up, Satya. Sorry, Sandeep. See, starting it says a person shall be eligible for appointment as an auditor of a company only if he is a chartered accountant. So first he should be a chartered accountant, provided further that every partner of the firm shall be a person who has been registered with the statutory institute. That means ICAI only.
No, Bhavani.
See, proviso, read it. Provided that a firm where majority of the partners practicing in India are qualified for appointment as aforesaid as auditor. That means majority. So minority can be not non-CS?
Earlier
also. Now also, minority can be non-CAs, but that minority partner must be registered with the statutory instituted body, which was not there. They bought this.
But what Madam is saying in subsection 1, it specifically mentioned about chartered accountant.
It is a chartered accountant.
Sandeep,
and the provision should
wait.
I'll add 3 things. One,
No, what I'm trying to say is very clear. Sandeep and Bhavani, it is very clear that first what it says that for an audit, you have to be a chartered accountant. Okay.
Right.
That is a must. Second, what it is saying that a firm can be appointed as an auditor. Okay. But who will be the signing partner? The signing partner will be a statutory auditor. I mean, a chartered accountant only.
Chartered accountant. Yes.
But the firm is who is being appointed as the statutory auditor, but the signing partner will be a auditor only, a statutory auditor, a chartered accountant. But here, what happened earlier, a firm, in case if majority of the partners of the firm have to be chartered accountants, but there are other partners also. If the other partners have to be registered with some kind of an institution, like it can be having as a CS as a partner, or it can have a cost accountant as a partner. As long as they're registered, then that firm can be appointed as this thing. They're just adding that.
No. To put it simple, madam. See, Bhavani, at present, all partners need not be CAs if a firm is appointed as an auditor.
No. I got your point. I understood.
You got it. So there can be non-CAs, there can be non-CAs. Now they're trying to bring in more clarity, trying to say that if the partners who are not non-CAs, they must be registered members with the statutory instituted body.
Understood. Yeah,
Yes.
yeah. This is proviso to proviso.
Yeah,
Right.
provision to provision.
All right.
Shall we move?
Yeah.
144, auditor not to render certain services.
Here it's only, and we need to understand further only by when the rule comes in. It says that for such class, say non-audit services, some prescribed non-audit services are there which they can do. But for such class or class of companies, even they can't do that non-audit services.
Okay. I think there is a
that an auditor audit firm of such class or class of companies as been prescribed shall not provide directly or indirectly any non-audit services to the company or its holding company, subsidiary company. So they're trying to
cooling off period.
Not cooling off period. They're trying to even restrict the auditors from providing non-audit services.
Simple exhaustive list. Matlab, they are not specifying what is excluded. They're excluding everything other than audit.
No, Bhavani. Today, they're giving a list of services, non-audit services.
Correct.
What it says that, say, read out section. Sandeep,
account and bookkeeping services, internal audit.
Section, read out for better understanding. Go up, little up. Yeah. An auditor appointed under this act shall provide to the company only such other services. That means only the following other services is permitted to provide. But for the proposed amendment is that for such class or class of companies, even these services cannot do.
Non-audit services includes everything.
That's what exhaustive list, meaning even they can't handle A, B, C to F, whatever, I.
Yeah, non-audit service they can't do. They have to do only statutory.
Correct.
They want to restrict the auditor from providing other than audit service.
Correct.
I'll read out the provision, sir. Provided further that the restriction under this section shall also apply for a period of 3 years after the auditor or audit firm has completed his or his term under this subsection.
Yeah,
cooling period.
No, not cooling.
Next 3 years.
Not cooling period. While you're an auditor, you can't provide non-audit service. Even after you resign, vacate as an auditor, 3 more years your restriction is there for you. You can't provide non-audit services.
After 3 years, you can.
During your appointment as an auditor, apart from that, 3 more years after your tenure completes.
Okay. Shall I move? 147, punishment for contravention.
It's only like, that 1 lakh rupees.
Okay. Penal. Fine to penalty.
Yeah.
148.
What is that?
Cost auditor.
Cost auditor. But not measure. And this is similar provision they're bringing across all the 3 professionals.
Okay.
Go ahead. Here, interesting thing. What is this? Section 149. Company to have board of directors.
Right.
Company to have a board of directors. Okay. Second, company secretary. The words. Number of companies.
Why secretary auditor is there, sir, here? Under section 149.
In subsection 2.
Instead of company secretaries in practice, they want to use the word secretary auditor. That's all.
No, you go back. I think, this subsection 6 they are trying to bring. First, see what is subsection 6. You have to come down.
It is similar to IFP. Cannot be.
Yeah, Mohit, what you're saying? Mohit was saying something.
Yeah, it is similar to IBC, ma'am, like where RP or IRP cannot, related to company, cannot be appointed as the IRP or IRP. Similarly, in like any secretarial auditor cannot be appointed as an independent director.
You see these existing subsection 6 and the existing subsection 6 basically.
An independent director in relation to a company means a director other than the managing director or a full-time director or a nominee director.
Who is in the opinion of the board? A person
who is in opinion of the board in a person or integrity and
process
relevant expertise.
They are trying to disqualify secretarial auditors to act as independent directors.
Okay.
They're trying to disqualify secretarial audit. Now they are trying to disqualify, I think, even auditors also. Auditors, cost accountant, registered valuer, blah blah blah.
This move is not welcomed.
No. It's already there. See, company secretary in practice. See, you see what is there. In class 2, go back to the class 2, what of existing provision? in item A. Subsection 6. Come down, down, subsection 6. What it says?
Okay.
It says a firm of auditors or company secretary in practice. See the word company secretary in practice, they're replacing with secretary auditor.
Okay.
It's not a major. There is no change basically because they're trying to now call the like you are statutory auditor, you are cost auditor. Likewise, you are secretary auditor now.
No, but what is the amendment proposing? They are saying that these guys cannot be appointed as a director in the company.
Even today also, company secretary in practice, you can't appoint.
You can appoint as an independent director.
No. Not in the company where you are doing audit.
Not in the company where you are doing audit, no.
Okay. Okay then. So
they're just replacing the word auditor. That's why there's nothing much over
here. There is no change here.
There's nothing much over here.
Apply to an independent director, he may continue as an employee. Okay.
That where he may continue as an employee, proprietor, part that what we have to see what is subsection B. I think he has 6. Where the provisions of item B of subsection 2 applies to independent director. You may continue as a as an employee, proprietor, partner of a legal or consulting firm in case the transactions of legal or consulting firm with the company holding subsidiary is less than 10%. I think this is in case to encourage instead of discouraging the right fit for people to invite into the board as an independent director. I think if you have to be independent director, you should not have any monetary relationship with the firm where this company is contracted with. So now it says that no, you can continue provided if the monetary transactions with the legal or consulting firms is less than 10%.
Okay. So the restriction is there on appointment.
No, relaxation is there.
Relaxation.
Assume that you're appointing a partner of a legal firm or any consulting firm where there's a monetary transaction between the company and the consulting firm. Today I think it says that no, you can't continue as a partner. In case you want to be an IT here, then you can't continue. Or rather you disqualify. Now they are qualifying them provided if the transaction value is up to 10% of the turnover. Or lower percent. Come down.
Shall I move to the next section?
Move.
152. Appointment of director.
152, it says that shall be appointed, shall continue to function. What is that? Section 3. Go. Yeah, no person shall be appointed. The word appointed is
appointed shall be substituted, shall continue to function
as a director of a company unless he has been allotted there. So this is very. I think this provision has no meaning today because you can't have a director without a deal today. This is maybe this is one-time transition. I don't see also this is a transition provision.
The words second one is after the said that DIN or the other number is not deactivated or cancelled.
Okay, yeah. See, no person shall continue as a director of the company unless he has been allotted DIN or any other number as prescribed under section 153. 153. They're saying and the said DIN is not deactivated. See, if in case the DIN is deactivated or cancelled, he can't continue as a director of the company. That is an amendment.
Right. Okay.
So now there is a provision here, non-filing of financial statement, your DIN may get deactivated. Once the DIN is get deactivated, you disqualify to be up as a director of the company.
Right.
Yeah. So I think they are bringing more elaborate provisions with respect to DIN. They're trying to bring, DIN number is now becoming more and more crucial for the companies and for the directors rather. And so they're trying to bring some discipline with respect to DIN. At present, today, the existing provision do not have that. What it says that, no, there is a provision which says that if the company's directors are disqualified under section 164 and 167, there is a disqualification of directors and vacation of directors. When that provision attracts, then their DIN gets DIN will be deactivated or DIN may be cancelled for non-compliance. When the DIN is deactivated or cancelled for non-compliance, then he is disqualified to act. This becomes one of the ground for appointing as a director. That is a provision. And there is a provision for again reactivating the DIN which is deactivated, or restoring the DIN which is cancelled. So those provisions are introduced here.
Okay.
That is this implication of these changes. Next, go. Again, penal provision, you skip it.
Additional director, I think there is a major
additional director, the important amendment now, the restricting tenure of additional director is only for 3 months.
Okay.
Or only 3 months, or up to the next general meeting.
Okay.
The tenure of, see, today at present provision is that, no, it says that what the articles of the company may confer it board. A person to file get appointed director in general meeting
till the next AGM.
Yeah, see, the provision says if a director is failed to get appointed in the general body meeting, you can't appoint such person as additional director. And if you second, if you're appointing a person as an additional director, then his tenure is up to next AGM or last date by which AGM should have been held. That is the present tenure of the AD, additional director. Now the tenure of additional director is
3 months.
3 months or next general meeting, it says, not even AGM.
1 minute, sir. I will read it out. The changes: as an additional director at any time who shall hold office up to the date of the next AGM or up to the period of 3 months from the date of the appointment,
Not
whichever is
AGM,
earlier.
next general meeting.
Next
general meeting. Okay,
so,
next general meeting.
I will add my points here. Basically, see, in the whole scheme of Companies Act, the power to appoint directors lies with the company general meeting only. But in exceptional cases, you have provision to appoint additional director, wherever the board feels that no, the urgency to add somebody on the board, to take their advice services, blah blah blah. As an ad hoc requirement, you will appoint additional director. And alternate director, we all know that no, when existing director is out of country. If there is a resignation and death, blah, blah, there is a vacation causes, then you can appoint a casual vacancy director. Otherwise, under the Companies Act, appointment of directors has to happen only in the general body meeting. That means shareholders are supreme and shareholders only have to appoint directors. So, but if you appoint an additional director, let us say immediately after AGM.
His tenure will be 1 year.
His tenure is up to next AGM.
Right.
So the very principle that no appointment of the directors in the company should be done only by members in general meeting, that provision gets diluted. So there's a loophole for the people to appoint after AGM, and you will continue. No, in case you feel that no, you will not get appointed, so you can appoint a director after AGM, and you will terminate up to next AGM. So when the supreme rule is that no members only should appoint, this provision is trying to bring in line with that. If you're appointing a person as additional director, he should be regularized. That appointment should be ratified and bring as a regular director by members in next general body meeting, not even AGM.
Sir, I have a question here. So generally, as per the previous section, you regularize. That is a word which we use. It's not mentioned anywhere in the Companies Act. We appoint him as a director in the AGM. Now, in this case, if there is a tenure is only for 3 months, and if I convene another extraordinary general EGM for the purpose of his appointment, so as an additional director, will he do we need to file a DR12 and again resign him and again make an appointment?
That there is no change in that. There is no change in the filing requirements. The major change is that if you want to appoint somebody as an additional director, his tenure is maximum 3 years.
3 months.
3 months. 3 months or next general meeting.
See, whichever is earlier.
Whichever is earlier.
So
that means maximum is 3 months only.
Maximum 3 months only. So I'm saying that. Why that 3 months? Because the shareholders is supremacy, and they only have to appoint. Board want to exercise that power. You have power to exercise that power to appoint a director only for 3 months. That's all.
They are
Maximum
bringing this in
3
line with the SEBI regulation, which has come
Yes,
for
yes,
listed
yes.
companies.
Maybe,
Yes,
madam.
yes,
Maybe.
yes.
Yeah.
So in this case, if 3 months are over and if you're convening a EGM, then you file a DR12 for his session, then
Vacation.
again appoint him.
As an additional director, vacates. He vacates when? At the general body meeting, which happens before 3 months?
Right.
Or automatically
Or 3
at the
months.
end of 3 months.
Okay, understood.
Filing requirement will not change here.
Right.
These provisions are already introduced in LODR regulation.
LODR
Now
regulation.
they have brought it to the Companies Act now.
Yeah, that's what madam is
Yeah.
Already. Anything else in 161? Shall I move?
Move.
Okay.
No, that's
Disqualification.
I think we should stop in the next 10 minutes. It's already 2 hours. We can
Actually,
continue.
I was waiting for.
150.
Actually, I was waiting for merger. I was like, when section 230 will come, and I will. But
Not
it is
major
like it's
changes.
continuing.
Not major changes in merger.
If there now the additional director was a good change. If there are any major change, we will discuss the major change and we can move on.
Yeah, okay. 152, I'll tell you. 152, it says that disqualification of appointment of a director.
164.
154. Auditor, secretarial. Come down. Auditor, secretarial auditor, registered valuer, cost auditor, insolvency professional. Now disqualified to act as a director of the company for 3 financial years.
Mm-hmm.
Okay.
It was there in 152 also.
That's all. 152.
The restriction.
If the DIN is deactivated or DIN is cancelled, is a disqualification.
So you're saying.
And if the DIN is deactivated for the purpose by the reason of section 164 subsection 2, that is non-filing of financial statements annual return. In such case, next amendment is that in such case, the existing provision says that he vacates the board of all other companies. Now it says he will vacate only after 6 months. Go back to the next section. You want to run no quickly?
Lots of changes in 164, it seems.
Oh, yeah.
I think there is one major change with respect to number of years.
Another interesting disqualification here is that if he has not been assessed by the board to be a fit and proper person, one of the grounds for disqualification is that board has to first assess him that as a wait, don't run.
Yeah.
Down it is there. Down it is K. One of the additional ground they're proposing to introduce is that if the such person has been assessed as not a fit and proper person, then he is disqualified to be appointed as the director of the company. The question comes when most of the appointment happens with the concurrence of the board only. Why will a board invite a person who is and later assess him as not a fit and proper person? It is obvious, right? If you're inducting a person, you will have a formal consultation, then only appointed. So when will they assess? Is it that every appointment required to be assessed by the board that it should be fit and proper? Need that. If the board decides assesses him as not fit and proper, it means it is a weapon available to the directors, board of directors, that in case if a company receives a notice for appointment of a person as a director, like member proposing under requisitions meeting, if member wants to appoint somebody, propose a resolution in the AGM for appointing somebody as a fit and proper person, as a director, then board can come here and say and declare that he is not fit and proper person. So another weapon available to the board to ensure that to reject such proposals if he is not a fit and proper person.
Okay. Another thing, this 2 years, sir. Earlier it was 3 years, 3 financial years.
Yeah,
Substituted to 2 years. If you don't do annual filings.
2 financial years.
2 financial year. Earlier it was 3 financial years.
Yeah.
Now it's 2 financial.
Is there no left side? It's there 3.
Yeah.
Next, go next. 165 under this. Nothing, not much.
Okay.
Number of directors, 15 can be read. Yeah. Okay. Duties of
the director.
Duties of directors, no, they're more, they're trying to, in the duties of directors, no, in case if the director's duty is found to be guilty, and then he should make good, and he'll be subject to, I think, penalty of 5 lakhs. Apart from that, court may also order such director to pay the amount of undue gains referred to in subsection 5 to that company.
Okay.
A director shall not attempt to achieve any undue gain. See, this is the duty of the director. If he is found guilty, proved guilty under this class of section 5, the penalty is 5 lakhs only. But undue gain, whether you recover undue gain, the act is silent. So now the act is bringing that. Then if you determine that no, he has made an undue gain by his acts or conduct, he will be asked to refund that. 167, vacation of office. This is the major amendment coming here, is that so where he incurs disqualification under subsection 2 of section 4, the office of director shall become vacant in every company where he is a director, including the company which is in default under that subsection. Please understand, I think including the company in which present provision does not provide for vacation into the existing company where that's disqualification.
Right.
But here is trying to cover even the existing company where the disqualification attracts, and his vacation. See, at present today, 167, if attracts, it is automatic vacation.
Immediate.
But you attract is automatic vacation. But now they are giving a period of 6 months from the date of incurring such disqualification. Okay. Take an example. Non-filing of financial like balance sheet and annual return continues for 2 years. So last day by which you have to file, from that day, 6 months period is there.
Okay.
So that is an addition here. Second, I think, come down.
After this section?
Ramki, what happens in case if within that 6 months the company makes good and they file the documents?
Yeah. Yes, that is the Sandeep, go up. Yeah. No, sir.
Madam, I think disqualification once impacted is impacted.
No, Bhavani, somewhere, see if you
No,
make good,
that's 6, then why the 6 months provision has given then? They should be immediate.
Because they need to appoint a new director, right?
164.
There cannot be sudden vacation in the board, nobody will be there. So probably they must have given 6 months time.
No, that is one, Bhavani.
Then why 6 months? They should give 3 months, or there's enough.
There is a relevance to what Madam also saying. There are some of the cases where we made the non-compliant. Non-compliance is what the subsection. Sandeep, you see, 164. Go back 164. Go back 164.
164.
Subsection 2. Here only. Subsection 2.
No person. This one?
has been a director of a company which has not filed. Not filed financial statements or annual return, has failed to repay. So when they make good, now today the non-compliance is made good. So that argument was what? In one of the occasions, that argument was what Madam is saying. So correct. So maybe you have been given a window to make that non-compliance good within the 6 months. If it is right, Madam was asking, if you make the non-compliance good, whether it continues.
But such a cushion is not there, right, Ramakrishna? As you said, if that cushion was there, that particular clause would have been incorporated there. That cushion would have been incorporated. But right now it is silent about it.
Subsection 1, 164 subsection 1 versus 164 subsection 2.
And one more clause is also there. I don't remember where it is. In case of these kind of defaulted companies, if a new director joins as a director, he is given 6 months window to ensure that past filings are completed. That clause is there.
No, well, that clause, maybe we have to examine that.
So 6 months they have given time for the old director. Sorry?
Where is that clause?
Vacation only. I don't remember. Maybe Sandeep, go to the left and just check it out, na? 6 months time is given for new director who joined this defaulted company for a period of 6 months. Existing is there.
No, existing only. This is existing 167.
The office of director shall become vacant in case. Come down. It should be in subsections only or additional provision. That is not added.
He is convicted by the court. Okay, and sentenced in prison not less than 6
Come
months.
down.
Here
Come
only,
down.
6 months. Somewhere there only. He is convicted by a court of an offence which involving moral turpitude or otherwise, and sentenced in respect thereof to imprisonment for not less than 6 months. Bani. This is only 6 months reference.
No, that clause is entirely different. In case of disqualification, if both the directors got disqualified, new director you should induct, right? Okay. So when you induct a new director, he will have a cooling period of 6 months for him to make good the old non-compliances. After 6 months, he also becomes disqualified.
I have not seen it in this anywhere.
It is there, madam. I'll share it with you later. It is there.
We will see that. But so my analysis subsection 164, subsection 1 and subsection 2. So then go. Subsection 1. See, who is disqualified? See, a person shall not be eligible for appointment as a director of the company if he is unsound mind and stands so declared by a competent court. Fine. Once he is an unsound mind, he can presume that he is continuing to be unsound mind. Second, he is an undischarged insolvent. Once his insolvency is discharged, he is free from this insolvency. He is free, and he gets qualification to get appointed as a director. And third, he has applied to adjudicate as insolvent and his application is pending. Assume that now this application he withdraws and then he becomes solvent. What happens? Whether disqualification continues? No, disqualification will not continue. D. You see the D. He has been convicted by a court of an offence, whether involving moral turpitude or otherwise, and sentenced in respect thereof to imprisonment for not less than 6 months. And a period of 5 years has not elapsed from the date of expiry of sentence. That means after the expiry of 5th year, he is qualified again. So when every provision has a window, that one point of time he becomes qualified back. Likewise, subsection 2, if non-compliance is made good, you should be permitted to qualify back to appoint as a director.
Because under section 137 and 92, you have an option to pay for additional payment.
Yeah,
now again, CFSS is coming. If I file all the 3 years of filing now, then I think it should come back.
No, it cannot be permanent disqualification.
But what in case where the ROC drives for a purpose of disqualification and then they disqualify? I think they cannot be come back and get appointed.
Right? Whether by making good the non-compliance, automatically he gets his qualification gets restored to him, or any cooling period or not, maybe we have to check there, because somewhere the provision is there. No, once the disqualification attracts, here I think now I'm recalling, once the disqualification attracts, his DIN gets deactivated. So then he has to get the DIN activated to him to be qualified to be a director of the company. That is there under the provisions of 167 also. So I think, madam, see the board.
So right now the takeaway is to
non-filing will have a consequence of DIN becoming deactivated, and in case you make good and make the DIN active by following the due process of the procedure under section 152.
No, but when will the DIN get deactivated? Because he's saying that they have within 6 months, right? After 6 months, they will get disqualified now under the new provision.
After 6 months, you
but even that within that 6 months,
DIN will be deactivated only. Madam, DIN will be deactivated only in the case when the ROC has taken a drive and disqualified the director.
No. My question here is that you have that 6 months. After 6 months, you get disqualified. If within 6 months the company has made good, filed all the documents, then does he continue?
It should continue.
Maybe that we need to, if there is any scope, we have to ask these questions and tell them to clarify these points.
But right now the takeaway is 2 years and immediate disqualification in the company and in the relevant company, and 6 months in other companies.
Vacation after 6 months, not immediate.
Immediate in the same company, no sir?
No, nothing.
Nothing. 6 months. After 6 months from the date of incurring such disqualification.
Okay.
See, this is an exception. That's what I'm saying. See, 167 is an automatic vacation. 167, the moment you attract disqualification, You don't need to do any act. Automatically,
Sir.
by virtue of law.
Sir, on 7th May 2018, notification came stating कि if a person is been appointed where it is a disqualification for non-filings of annual financial results and all, the 6 months time period is given for him to make a good and he will not be disqualified. If he doesn't file, what Bhavani was saying was right actually. He new director can be appointed and he will be given a period of 6 months time. It's been given in under section 164. You can see to the amendment on 7th May 2018.
Amendment to the Act on 7th May 2018.
7th May 2018, this was amended, and they said that a new person who has been appointed now for a disqualified person, he's been given 6 months of time period to do so. 160.
No, Lakshmikant, here the question
is, that is 164
fine,
subsection
that was immediate disqualification. Now the provision, there is a new saying that he will vacate after 6 months. My question here is that if within that 6 months that company makes good and does all the filing, does this director who was there still get disqualified? But if it is already made good, whether if it's a new director appointed or the same director is making good, he can continue, as director. The question is that.
No. The question, one, it is automatic vacation, madam. Why we are talking about 6 months? 6 months is, we are talking, right? Why only 6 months? Why not 3 months? See, not necessarily in 3 months you will get a director and he will be able to file the forms and all.
I'm saying, but vacation, he vacates after 6 months. It's not automatic vacation. They're saying he vacates after 6 months. See the wordings.
Acha, as per the new definition. Okay.
Sandeep, go back to section 164. 164, subsection 2, proviso.
Subsection 2,
maybe
proviso.
Subsection is there, one. It is there. Yeah, subsection 2, proviso. You read this.
B is there. He shall not proviso that provided that where a person is appointed as a director of a company which is in default of a class A or class B, he shall not incur disqualification for a period of 6 months from the date of his appointment.
So this kind of cushion should be given for those, the current disqualification, vacation also.
No,
he have explicitly mentioned he will not be, he will not incur disqualification.
No, it is for the company which has incurred disqualification. But whereas he vacates in all other companies. See, he is attracted disqualification by virtue of non-compliance by company A, and he is a director in that company A. He can continue for 6 months.
Correct.
Right?
Only
company A. Company A.
Yes.
But now this 6 months is extended to even all other companies.
Correct.
It's not extension of this disqualification across all board. But when the question is within 6 months, if you make good, whether he becomes qualified to continue.
That's what Ramakrishna. If that is the intent, they would have mentioned they will not incur disqualification if you complete the filing within 6 months' time. That clarity would have been given there.
It's not there.
It can come in the rules, I think. It might come in the rules.
Maybe. If at all, if some cushion is there, it should be provided. Otherwise, it is restrictive or prohibitive only.
Correct.
Yeah. This is a question actually we can discuss in tomorrow's meeting.
Yeah, tomorrow is there.
So, sir, I think it's more than 2 hours.
2 hours.
So shall we wrap it up to 167, and from 173 we can have another session?
Another session, more detailed session. Okay.
Okay, sir. Then thank you very much for this enriching session, and we will hopefully get back for part 2 of this company's corporate law amendment bill 2026, and we can also see whether Rajya Sabha has this bill has been passed or not, right?
Sure.
Okay. Thank you.
Thank you.
Bye.